Hi, my name is Kristen, and today I'm going to be doing my CAP presentation on the legal issues in kinesiology. So for my facility, I've decided to do an athletic training facility as I am a certified athletic trainer. It is a unique occupation in that our quote facility can be anything from a football field to a baseball field to a swimming pool and even the athletic training room. So it's very broad and can therefore have several legal issues attached to it. So, first subject we're going to be discussing is risk management. Um, I have three cases that I have outlined. So, the Howard versus Missouri Bone and Joint Center focuses on the plaintiff, who is Howard. He visited the Bone and Joint Center for wishing to increase his training. He had previously sprained his ankle and just wished to get back to his previous level of activity and performance. Um, the athletic trainer who's going to be organizing his training did do an interview to begin with, and some testing and measurements and such, but neglected to ask him the last time he had worked out before starting their program. Their program consisted of a squat program in which they increased the weight and intensity. Um, After the second visit, the plaintiff complained of severe back pain, where the athletic trainer kind of brushed it off, prescribed stretching, and said, kind of, you'll be fine. The plaintiff ultimately um, caused permanent damage and severe pain, and the case was decided in favor of the plaintiff. So this just kind of outlines the importance of a pre-participation screening. The NATA doesn't have a position statement necessarily following the training, but it does have a position statement regarding those pre-participation screenings, excuse me, and the importance of those, and any disqualifying conditions that an individual may or may not have. So the next thing we're going to talk about is concussion care. This is seen in Kearney versus Cedar Bluffs Public School. In this case, the plaintiff suffered a traumatic brain injury after a second impact. So in a game, he got hit in the head, complained of dizziness, but stayed in the game. He did tell the coach he felt a little bit dizzy, but by the third quarter was feeling better and went back into the game. Played the rest of the game, and then the next Tuesday came to practice, also participated. And it was at that Tuesday practice following the game where he was injured again. And he sustained the traumatic brain injury due to that second impact. The NATA does have a position statement regarding concussion care and protocol. In this position statement, they do state that the athlete should have been removed from play following that initial impact due to his complaints of being dizzy, and should been evaluated by a physician before returning to play, including that Tuesday practice. The position statement also outlines the importance of education for coaches and administrators and parents and anyone that's involved in sports in general, because this case did not have an athletic trainer. It was surrounding coaches. It was kind of sticky in that area, but due to the standard of care for coaches, it was decided in favor of the plaintiff. And the last case for risk management that we're going to talk about is, I'm going to butcher the name, but Kleinschmidt versus Gettysburg College. So in this case, the plaintiff suffered a fatal arrhythmia at a lacrosse practice in which no athletic trainers were present. He fell and passed out, and none of the coaches were CPR certified, and there was no emergency action plan in place. So essentially, it was a mess trying to get athletic trainers to the field to provide prompt care. And that ultimately resulted in the case being decided in favor of the plaintiff due to the lack of prompt services for the plaintiff. The NATA has a position statement regarding emergency action plans and recommends that each facility have an emergency action plan with early defibrillation being key in this case. The plaintiff did not survive, and due to the lack of communication and emergency action plan, defibrillation and having a key system in place for those emergency situations is highly recommended. So moving on, we're going to be talking about employment laws and any legal issues following that surrounding athletic training. So the first one we have outlined is North Haven Board of Education versus Bell. In this case, the plaintiff stated that the district violated Title IX after she was not rehired after her one-year maternity leave. Because this case was argued in 1981, and in that time Title IX only applied to students, it was kind of sticky. But after this case, Title IX was altered in its verbiage to include both students and employees, and it did lead to the plaintiff's protection and determination of her wrongful termination. So it kind of outlines the importance of schools complying with Title IX. And again, although it was a teacher, because most schools are covered under Title IX, athletic trainers would also have to deal with this working in the school setting, specifically high schools and universities and such. So important for employees and employers to understand and follow the Title IX requirements. The next one is Stanley versus University of Southern California. In this case, Stanley was hired as the women's basketball coach, and during her time received a lot of success in her position. Her contract was up for renewal, and when it was up for renewal, she demanded equal pay between the men's and women's basketball coaches. There was a lot of back and forth with contracts and such, but ultimately the university decided to terminate her contract or not continue with her and went with a new coach. The case found that the pay discrepancy was in fact reasonable due to the differing experiences and qualifications between the men's and women's coaches. The men's coach was more qualified, and the men's team required different skills due to it being a men's team and being more popular and such. So it's important to notice, again, it's a coach but not an athletic trainer. Same rules apply, however, when hiring athletic trainers, it's important to note differing experience levels regarding pay rates and such. The last case we're going to talk about is Furr versus the School District of City of Hazel Park. In this case, both the men's and women's coaches did receive equal pay. However, it discusses the hiring practice at the school. Furr was the women's basketball coach when the men's position became available. She was one of two applicants and was the more qualified applicant. However, she was not hired for the position. This case was found to be unethical under Title VII. Due to her being more qualified and her being a woman and not being hired. And at the end of this case, she was ordered to be instated as the men's basketball coach as well due to her qualifications. So this case kind of outlines the importance of taking an individual's qualifications into consideration, and ignoring or not taking into consideration any aspect that's protected under Title VII. So in this case, it was gender. So for individuals who are employing athletic trainers, it's important to not take gender into consideration regardless of the sport. So all of these cases are extremely applicable to athletic training and my future career path. It's important to learn about all of these in order to better protect myself under any litigation. So making sure I have an appropriate emergency action plan for all facilities and communicating consistently with coaches. As well as knowing my rights under Title IX and Title VII as well, with employment and pay rates. And were I ever to be in a position of power doing the hiring, making sure I'm taking an individual's qualifications into consideration rather than their gender or their religion or anything like that. So with that, that kind of leads into the three verses I have. I have Luke 6:31, 1 Timothy 4:12, and Philippians 2:13. Luke 6:31, it's fairly straightforward. Do to others as you would have them do to you. So treat others how you would be treated. That works for other employees as well as any patients I may be dealing with. And then Philippians 2:3, do nothing out of selfish ambition or vain conceit, rather in humility value others above yourself. Again, same general concept, making sure I'm treating others well and not putting anybody down due to their race, their gender, their sexual orientation, or anything like that. And the third one, 1 Timothy 4:12, don't let anyone look down on you because you are young, but set an example for the believers in speech, in conduct, in love, in faith, and in purity. Being that I am a young professional, this kind of spoke to me because I should be setting an example for others in my position and those that I'm working with. My previous job, working with high schoolers, I need to set an example of what a professional looks like, and more personally, what a Christian looks like. However, as Christians, we do need to be careful in this because there are several legal cases. One, for example, is Engel versus Vital, where it was found unlawful to promote religion in public schools. And that ruling still stands. And although Title VII does protect talking about religion with coworkers, it does have its limitations. Specifically, like stop means stop. If someone doesn't want to talk about it, you need to stop talking about it. And you should not, under any circumstances, be talking about your faith with clients. And you can't let it interfere with your work. So those things are kind of important to remember as Christians, and protecting ourselves legally. Regarding situations in which our faith and our career may butt heads, I think it's important to remember our faith, but also kind of remember our scope of practice. So the two should kind of follow hand in hand, but for me, faith is ultimately more important. I would step down from a position if the two were to conflict in that way. So that's kind of my stand. Here are the references that I have. I've enjoyed this class and have learned a lot. Thanks.